You've probably heard people say that when a couple divorces, everything is divided equally 50-50. But if you've been following recent cases, you know that it's not that simple. Courts have made it clear that what happens after divorce depends on more than just the marriage. So, did the law change, or have we just been misunderstanding what equality really means in a marriage? Now, in this video, we'll be breaking down the legal framework governing matrimonial property division, what counts as contribution and how the courts evaluate it, property outside the simple marital purchase, and what are the practical implications of this. To explain this, I'll use the case of Federation Women of Lawyers Kenya versus the Attorney General. FIDA brought the case on behalf of all women of Kenya, alleging the violation of their rights and freedoms. They challenged the constitutionality of Section 7 of the Matrimonial Property Act, which states that ownership of matrimonial property vests in the spouses according to the contribution of either spouses towards acquisition and shall be divided between them upon divorce. FIDA argued that Section 7 of the Matrimonial Property Act was unconstitutional because it discriminated against women, which goes against Article 27 of the Constitution that guarantees freedom from discrimination and also equality. They pointed out that the law favors the spouse that can show financial proof and disadvantages women whose contribution is mostly non-monetary. They pointed out that women suffer the most after divorce because their contributions are harder to prove. They wanted the court to declare Section 7 of the Matrimonial Property Act invalid and that the Attorney General should change it to be able to divide the property 50-50 regardless of who contributed what after divorce. The Attorney General argued that FIDA didn't prove that the law was unconstitutional. He said that the law is assumed to be valid unless there is strong evidence to prove otherwise, and FIDA hadn't proven that. He also added that FIDA really misunderstood what equality really means in a marriage. Equality doesn't mean that both spouses have to share their property equally. It means that each spouse is given a fair chance to prove their contribution towards the property acquisition. He also pointed out that the issue of dividing property based on contribution was already decided by the Court of Appeal case of PNN versus ZWN. The sole issue for determination was whether Section 7 of the Matrimonial Property Act was unconstitutional. The court dismissed FIDA's petition. It explained that under Article 45(3) of the Constitution, both spouses have equal rights in marriage and when it ends, but that doesn't mean that everything has to be split 50-50. The court emphasized that equality in marriage means marriage is a partnership of equals, and that each spouse, both men and women, have equal dignity. However, when dividing the property, it's only fair that each spouse gets to, prove the contribution that they made towards acquiring that property. The court also said that the Matrimonial Property Act recognizes non-monetary contributions as long as each spouse can be able to prove their contribution. So it's not discriminatory. Section 7 is not discriminatory because it applies to both men and women, and that both financial and non-monetary contributions are considered when dividing the property. So in the end, the court declared that Section 7 is constitutional, and it's only fair that each spouse gets to prove what they contributed to acquire that property. Otherwise, people will be getting into marriages just so that they can benefit from the automatic half share of property they did nothing to acquire. To explain this, I'll use the case that I had mentioned earlier, that is PNN versus ZWN. This case involves PNN, who's the husband and the appellant, and ZWN, who's the wife and the respondent. They were married in 1961, they were both employed and had several children. In addition, they made sizable investment in property. So their marriage ended in 1987, and in 2001, P decided to move out of the matrimonial home and went to cohabit with another woman, MG. In 2004, Z decided to go to court, and she said that 5 properties, all of which were being registered under P's name, were actually being held in trust for her. She said that she wanted the trust to end and that the property be divided between them. She said that she had contributed both directly and indirectly to buying and developing these properties. P denied this. He said that he's the only one who bought and developed the properties. 1. What counts as marital property in this case? 2. Whether Z had proven that she had contributed to buying and developing these properties. And 3. How should the property be divided? Equally or based on contribution? The High Court had this case after the Constitution of Kenya 2010, but before the Matrimonial Property Act of 2013 came into effect. And so the court had to use the Constitution and international equality standards as its guide. So the High Court found that some assets were matrimonial property because they were acquired during the marriage and used by both spouses. And so the court used fairness and contribution to divide the properties. Some equal 50-50, while others were not, depending on the evidence that each spouse provided. P appealed the High Court's decision, saying the judge had made several mistakes. Firstly, he said that the judge was wrong to say that Z had actually contributed to buying and developing the properties because there wasn't enough evidence. Secondly, he said the judge erred in using the Constitution and international conventions instead of the principles from Echaria versus Echaria case. And lastly, he said that the judge was wrong to give Z a 50% share when there wasn't enough evidence to prove that how much she had actually contributed. The Court of Appeal dismissed the appeal, agreeing with the High Court. Z had proven her contribution, and the property was rightly declared as matrimonial. Justice Kiage agreed with the High Court, but also explained that Article 45(3) of the Constitution, which gives spouses equal rights, does not mean that the property must always be divided 50-50 in every situation. Property division is divided based on fairness and contribution. The Matrimonial Act of 2013, the Matrimonial Property Act of 2013, confirms this: ownership based on contribution, whether financial or non-financial. Justice Kiage also emphasized that the decision was still based in the Echaria versus Echaria case because contribution must always be proven and assessed before the property is divided. So from this case, what counts as contribution? The Court of Appeal made it very clear that contribution is not just about money. It includes anything that a spouse does that helps acquire, maintain, or improve the matrimonial property, whether directly or indirectly. So some examples of monetary contributions include paying part of the purchase price, paying rent, construction, or renovation costs, funding household bills that free up the other spouse's income to invest in property, and contributing to joint bank accounts that are used to buy assets. In short, if you put money in, whether cash, savings, loans, that is monetary contribution. And non-monetary contributions include domestic work and household management, childcare and upbringing, companionship and emotional support, supporting the acquisition and improvement of the matrimonial property, and participating in the family business. In short, if you made an effort that made it possible for the property to be acquired or improved, that's non-monetary contribution. 1. Property acquired before the marriage. So if one spouse bought or owned something before they got married, that is normally the personal property of that spouse. However, if the other spouse significantly contributes to maintaining, developing, or improving the property, they can have a beneficial interest in the property. So for example, let's say your spouse owned a piece of land before you got married, and then you maybe build a house on it or develop something on it. The court will recognize the court may recognize your contribution, but that doesn't necessarily mean that your property is now joint. 2. Gifts and inheritances. So for this, gifts and inheritances are normally the personal property of the spouse that receives it, unless they're registered in the both names of the spouses or they're converted into a matrimonial asset. For example, if you receive, an inheritance from your parent, like land or something, and both of you decide to build a family home and you live on it, that can be considered a matrimonial property because both spouses have contributed to the development and use of that property. 3. Property held in business or company names. So when property is registered under a company or a business, the law first recognizes it as belonging to that legal entity and not directly to either spouses. However, if both the spouses contributed to the business, then their shares or interests in the company can still be divided in a matrimonial property dispute. 4. The matrimonial home. The matrimonial home has a special legal status. Even if it's registered under one person, each spouse has a right to occupy and use it. And upon divorce, the court will assess each spouse's contribution to developing, maintaining, and improving it and decide on how to divide it. In short, not every property is a matrimonial property. The key question the courts always ask is, was this property developed, maintained, or improved through joint efforts during the marriage? If yes, then it is matrimonial property. If no, then it remains the personal property of that spouse. Now that we know how the law divides property, what does this mean for couples? Number 1, documentation is everything. Courts decide how to divide property based on proof of contribution. So you must show evidence of how you contributed to the acquisition, maintaining, or improvement of the property in question. Number 2, homemakers are recognized, but you still must prove it. The law recognizes the importance of homemakers and how they help, acquiring the matrimonial property. Things like domestic care, child support, emotional support, they are recognized, yes, but you still have to prove how your contribution, how your efforts helped the family acquire the matrimonial property. Number 3, 50-50 is not automatic. It's all about fairness. You see, the courts right now, equality doesn't really mean 50-50 or equal halves. Equality means that each person is given a fair chance to prove how they contributed to the matrimonial property. So sometimes it can be 70-30, sometimes it can be 80-20. The key thing here is fairness and contribution. Number 4, talk about issues of property early. Sometimes you can avoid that topic because it's not as romantic, but it's very wise. Talk about ownership, joint registrations, and contributions early so that you know where you stand. So, at the end of the day, marriage is about partnership, and the law recognizes this and accepts it and respects that. But when it comes to property, it's not about who loved who more. It's what you can prove. The principle is equality in dignity, fairness in division. So guys, that's it for today. I hope you got an understanding of how the courts divide property upon divorce. Now, let me know in the comments, do you think it should be 50-50 or, based on fairness and contribution? Make sure you subscribe, share, and like this video. See you in the next one.